Well, Dr. Atilla Kisla is the International Justice Cluster Lead at the Southern African Litigation Centre. Dr. Kisla, good afternoon to you, and thank you very much indeed for your time. How do you assess this latest application, or this latest request from our government? I mean, in a way, it's got very extraordinary features. It's such an urgent situation.
Thanks so much for having me. Yes, the application that South Africa filed yesterday is quite similar to a request that has been filed on the 12th of February last month, where the court, where South Africa was actually requesting additional provisional measures to prevent any irreparable harm. In that request, the court said the existing provisional measures are already sufficient to secure the rights of the Palestinian people. Now, what has been filed yesterday, the request adopts a slightly different approach in terms of the procedural law. And it is also, if you compare it to the previous request, has much more detail about the situation, and is of course up to date about the issue of famine and starvation.
There can be no argument over some of the facts. I realize in our first and maybe our second application you could argue the facts. But when the United Nations seems to say 20 children have died from starvation, and Dr. Kisla, I hate this, but I need to dwell on this for a second. We're talking about children, I mean in some cases very young babies, dying of starvation literally in front of us right now. I mean, there can be no argument on that fact. That must surely carry a lot of weight.
Certainly, especially because it's evidence that has been delivered or produced by the United Nations. So that carries a certain weight with it. And it remains to be seen where the court within its procedural laws or rules has to now make a decision whether this constitutes actually a change of the situation that justifies, for instance, a modification of the provisional measures. As you might remember, one of the provisional measures in the order from 26 January was with respect to basic humanitarian needs and access to food or water. So it remains to be seen where the court would see the need to specify its provisional measure to maybe be more specific in its order and the obligation that Israel has.
What happens now? How does it all proceed from here? We've given our paperwork in. I imagine the court is the court, so it requests Israel to hand in its paperwork. We never get to see Israel's paperwork for some reason. What happens after that?
So it's probably quite similar to the previous request from mid-February. So in that request, I think 3 days later, Israel had filed its submission, and 1 day later, the ICJ made the decision. So most likely, the procedural, the sequence will be the same. So in the next days, we should see the submissions by Israel, which are usually uploaded on the website of the International Court of Justice, and then the courts will most likely make a decision. It's probably also noteworthy that South Africa deliberately didn't ask for a public hearing, due to the extreme urgency of this matter.
Does the International Court of Justice get involved in cases like this very often? And what I'm talking about is the incredible urgency of the situation. I realize that there have been cases like, similar sorts of things in Myanmar, for example, in other places. And I think there's a case in Europe that people talk about because it set so many precedents. But has something like this happened before, where we can literally see, I hate to say it, children starving? I mean, I find it appalling. And judges, really are under pressure to act.
I think the situation is definitely quite unique and in its urgency as well. But there have been urgent scenarios or situations like this before, also in the jurisprudence of the court. I believe that this situation, however, shows how limited the options within the international community right now are. If we see entities of the United Nations cannot even facilitate the access of basic interventions, basic food and water supplies. So that shows how desperate the situation is. Another example of that desperation is probably that the USA, who is probably the biggest arms supplier to Israel, is at the same time supplying food over dropping them through airplanes. So I think that situation alone shows the desperation within the international community that we currently have.
It also seems to, I mean, I've heard critics of the USA, it just shows the absurdity of their policy. There's a bigger dynamic here, and this is maybe more of a political question than a legal question, but let me raise it, which is when we met an application like this, I presume it puts more pressure on the United States, more pressure on decision makers in the US. What I'm trying to get to is what seems to me at least to be sort of changing global opinion, moving really away from Israel, sort of towards the Palestinians.
Certainly. I mean, we saw that already after the order of the provisional measures at the end of January this year. And in the aftermath, we have seen, for instance, a case in the Netherlands where the court ordered the government not to provide, I think it was jet fighter parts to Israel. We have seen other applications in the US, in Canada, with respect to complicity of these states by providing, potential complicity of these states by providing arms to Israel. So there's definitely a trend and a shift in the shaping the public opinion. I think even if this request by South Africa won't be successful, it documents, and it also documents the reaction by Israel at this current moment in time.
Dr. Atilla Kisla, thank you. The International Justice Cluster Lead at the Southern African Litigation Centre.